Honorable Director General, Center for Joint Warfare Studies, Honorable Chair of this session, Admirals, esteemed audience present over here, ladies and gentlemen, boys and girls. I think boys and girls have left. So they are always on their toes. So last presentation of the day. I hope, although I am excited to deliver my speech, but the same level of energy may not be there on the part of audience. I know that, and my job will be to cut it short. So that is going to be my skill instead of transformative knowledge in regard to the regulatory regime of maritime, to which we say law of sea in the context of jurisprudence, the legal jurisprudence. That is what I can say. So quickly, I'll just give you a glance or a framework of the regulatory regime, because I'm more concerned with the regulatory regime of maritime and law of the sea water and oceans. See, I teach otherwise cyber law, and I also teach intellectual property law. Apart from water being a subject matter of our policy, I'm from Marathwada region, which is one of the most drought affected area, and water scarcity is there. So we have a center for water law and policy. As a result, as a part of it, we ensure water advocacy, and I have taken the job of water advocacy. And recently we have also taken, I was inspired by one university formed by Government of India in Gujarat, that is Gujarat Maritime University, and this specifically it is dedicated to the maritime studies, law of ocean study. Especially they have expertise in the legal field. Lot of regulations are being researched upon, and lot of awareness programs are being organized for the naval, the defense part of India. So that I think nobody could point out that we have a university dedicated to the maritime subject, and capacity building is being ensured through the university. So as a part of cyber law, I teach two principles. One, principle of notional extension. This is one principle, and the second one, the principle of cyberspace being a borderless. So cyberspace is truly borderless, and hence regulations are not easy to have, and consensus is very difficult so far as all countries are involved, put in together. So we couldn't have a cyber law. In fact, cyberspace is the only subject matter where there was a need to have a complete global regulation on cyberspace, but then I think UN community and countries across have failed. And there is another principle in cyberspace. I think there is a connection. This principle of notional extension, that laws are focused on territory, the territorial jurisdiction. One of the former speaker has mentioned this about the territory is very particular for the legal regulations, and as such, even for the Indian legal system, territorial things are more crucial. But then, however, law of sea is the only branch of area, one of those branches of law in the legal field, which starts globally and ends locally. I mean, normally, otherwise laws are made locally and then they are seen globally. So law of sea is an exception to it. So this is about the territorial extension, the principle of notional extension. Even criminal law of India has also codified a rule in Bharatiya Nyaya Sanhita, and the rule says that an offence is committed on ship, irrespective of the location of the ship, FIR can be registered in India. So this is called notional extension of Indian laws on ship. All right. So now moving further. Territorial jurisdiction, as I told you, is one of the significant key aspect of legal regulatory regime, and normally, as I told you, law starts locally and inspires globally. However, in the case of law of sea, because of the peculiar nature of this subject matter, the global forces have swung into action, the global community has swung into action, and since there was nothing with the countries and the legal system and the sovereign states to regulate on their own, so global community and global world community had to take initiative in this regard, and there have been initiatives taken. So initiatives have been taken at the global forum first, and then as a result of it, the countries across the world, the member states of these global documents which I am going to discuss, they are under legal obligation, they are under international obligation to follow those conventions which have been formulated by the world community. In case they do not follow, it has its own sanction. And maritime is one of those global forces for which countries have to comply with. Otherwise, it's not like some private relationship or private obligation the global community is trying to regulate. It's not about that. It's a serious business. The serious business is about conservation of environment. The serious business is about protection of the nationals. The serious business is about flourishing of or promotion of giving rise to trade and investment, because trade and investment, another subject matter, another area where global community has joined hands, and like maritime, and even trade laws, if you compare with the maritime law, is having a global force, and countries are under legal obligation to follow it. So like trade law, like cyber law, like human rights law, and like e-commerce law, maritime law is part of that league of international law which is having a binding force on the countries which are part of it. And this binding force is not because of legal principles, this binding force is because of necessity, because maritime is a necessity. So I'll quickly try to take you to the entire legal framework. I know I have very short time. I wanted to discuss about my university, but then I don't have time, so I will skip this thing. I am from Maharashtra National Law University, Chhatrapati Sambhajinagar, which is in Aurangabad. And this is about my university. Our chancellor is Honorable Supreme Court Judge is our chancellor. We have faculties, we have 500 students. We launch many courses. Especially we also run PG diploma in water law and policy. As I told you that we have a center on water, dedicated center on water law and policy. So regulatory aspect as well as policy aspect that we discuss, that we do advocacy for. Now presentation, this is the outline of, not this is outline, this is actually the outline of our presentation. This is what I have prepared. Conceptual framework of water laws, because when we discuss water laws, we need to discuss from 2 points of view. One, inland waters and ocean waters. So law of sea is different and inland waters thing is different, because inland water is a part of territorial jurisdiction and countries are having dominance on inland water. So there are different, that is different arena. Like for example, there's the inland water treaty between India and Pakistan. Recently this treaty was stopped for certain reasons that all of you are aware of. So that is based on treaty. So this is called bilateral treaty. So this law is between two countries. This is not a multilateral treaty like all countries have contributed and have formed this agreement. So inland water or fresh water or consumable or drinkable water laws are different. So I have also prepared few slides dedicated to inland water or fresh water as well. But then first few slides are about the law of sea, that is ocean. The second part is about nature and structure of international law. The regulatory regime of law of sea is not to be understood unless you understand first the nature and structure of international law, because scholars have ascertained, and even that is what the reality is, that international law is not a law in true sense, because laws are applicable to sovereign states and there are no global laws. Except few things, like as I told you, trade law is an exception, cyber law is an exception, human rights is an exception, and maritime is also, law of sea is also an exception to the fact that the aspect that international law cannot be a truly global law in true sense. There is a jurist called Austin. He has provided this theory, and he is of the opinion that international law is only international morality and it cannot have a binding force on all the countries. So it remains a morality, part of morality and ethical considerations. It all depends on country. If they want to follow it, they can follow. If they want to do away with, they can do away with. Like that, the perception about international law is there. This perception I'll discuss very quickly, because that will decide the fate of law of sea. And before I discuss these slides, I am telling you conclusion in advance that maritime law or law of sea is having binding force, and the principle that that international law is merely a moral principle is an exception to law of sea. And law of sea, so in fact, law of sea is an exception to the principle that international law is based on morality or something like that. Third part I have dedicated exclusively for the structure of international maritime law. I cannot decode entire maritime law because time is not there. I will only tell you the tripartite structure that is there in the law of sea. There is a tripartite system. Tripartite system in the sense, in the hierarchy, there is a UN document that is there. A couple of UN documents are there. Document in the sense instruments and laws. And second second item in the hierarchy is the regional arrangements that is made in case of law of sea. And at the same time, there is international organization dedicated exclusively for law of sea, and this international organization has been given with authority and power to lay down laws from time to time, and they have laid down laws from time to time to regulate and govern several aspects of law of sea. And then we have local laws. Local laws, they have to design local laws dealing with ships, ports, and seafarers. and navigation and all that. Local laws are to be framed keeping in view their international obligation as a result of UN law on law of sea. So that is what the point number C. And D, point number D is about international and national regime on fresh water. That I may skip as a part of this slide. Quickly going on. So this is what the distinction which I have made as a part of my slide. Maritime water ecosystem and freshwater ecosystem. I know we are not concerned with the freshwater ecosystem. We are purely concerned with the maritime water ecosystem, wherein these are the major affairs for which international development, regional development and local developments are taking place in the field of law. Naval affairs, natural resources, navigation, shipping, waterways, trade, commerce, defense, biodiversity and livelihood. Everything. Livelihood I think could not be touched upon by previous speakers. It's a part of livelihood. Many communities are, their livelihood is totally depending on seawater. Especially some communities in Andaman and Nicobar, they could not be a part of the mainstream life. So they are heavily and totally dependent on the seawater. So international laws have been designed keeping in view their affairs. So nobody can, encroach. Just give me a few time. I'll try to cover my entire slide. Alright, so part B, nature and structure of international law. This I'll come in the end because that is what the major flaw. I mean, countries across the world, they are not following international law. Like for example, I'll give you an example of US. Despite law of sea having a binding force and is a matter of necessity, matter of human existence, question of human existence, still USA did not become a part of UN Convention on Law of Sea because of its national, economic and social security that they feel will be compromised. So that is one of the major flaws. So when USA, being one of the giant economy and technologically advanced country, is not part of United Nations Convention on Law of Sea, then what is to be expected from smaller countries? So that is what the international law problem that we find in international law, that countries are not binding themselves to such a matter, laws of such a significant nature. So public international law, private international law and supranational law that we discussed. Law of sea is part of public international law. There are private international disputes as well. But then because of UN convention, those private disputes between two merchants, it has become a part of public international law and countries will tackle and countries will deal with it. Any dispute arising out of unfair treatment given to seafarers or merchants by countries within whose land they have been caught or they have been prosecuted, the matter goes to the international court established specifically for, international tribunal specifically established for dispute resolution mechanism in this regard. So this way, even private international law, merchants disputes, has assumed the character of public international law and countries will take care of it. So countries will represent these merchants in international tribunals. That is what this slide says. The structure of, so this structure of international law is from the point of view of law of sea, that is ocean and sea water. So so there are different types of law, different nomenclatures are there in international law: declaration, convention, treaty, covenants and agreements. Now so far as law of sea is concerned, expression used is convention. Now convention is also just a congregation of all the countries, they have come together, they have signed and they have ratified. Signature and ratification, these two are significant aspects of any international law applicable to local countries or national countries. Once you sign a particular international convention, it does mean you agree in principle that you want to follow. You agree with the concern or necessity. And once you ratify after signature, it shows your commitment to implement in your country. Like for example, ships, ports and navigation. All rules, norms in country's law have to be designed keeping in view international law. So that is what the significance of signature and ratification of international law in a particular country, because international law directly is not applicable to a particular sovereign country. It comes through a process of the parliament. So this slide is about the structure of international law. Quickly, this is all you are aware. Why admiralty law? This is law of sea is also called as admiralty law. And why admiralty law that we need? Because of maritime operations, because of maritime activities, because of subject matter. One more principle that we teach in cyber law and that we always take name of, that being what you can't do in offline world, you can't do in online world. The same thing is applicable here as well. What you cannot do in territories to which there are laws, the same thing you are not permitted to do when it comes to ocean or ships or any subject matter which is a part of sea. So same thing, same logic goes, because law is logic, and thereby all operations, marine operations, all activities, maritime activities and entire subject matter, whether it's a ship or it's a seafarer or it's a labor or merchant or foreign national, all are subjected to the laws, and there are rules as to their behavior, their activity and their operations in marine affairs. So these are some examples which I have given. All laws have been designed, whether at national level or international level, keeping in view these subject matters and these affairs, cargo damage and collusion. So there are contracts, there are clauses in contract to go for arbitration, or they may also go for international tribunal as well. There is a provision for that. The delay in deliveries, lost packages, seaborne trade, maritime transport, customs, coastal affairs, all these are part and parcel of laws. And UN Convention on Law of Sea obligates all countries to make law on all the subject matters, and we have made laws. So natural resources, as I told you, human rights is the base of any national law or even international law. Even law of sea is based on the world's commitment towards human rights. And accordingly, natural resources, they are meant for living beings as well as human beings. So that's the philosophical foundation of law of sea, that oil, gas, minerals, fishing, marine minerals, biodiversity, ecology are to be protected even in ocean as well. So activities, piracy, one example I'll take, I will not go through all activities. Operations, sustainable practices, recycling of ships, even there are laws and rules so far as how to recycle the ships which are not being used, which are abandoned. Labor conditions, personnel conditions, how personnel are treated, their working hours, safety, security, welfare and all that, everything is codified in the law. Please give me some time so that I can, because I have traveled long way. So I should justify my job, my role being here. Just 5 minutes I'll take and I'll sum up. So these are the subject matters which law deals with. UN. Now this is what something, UN Charter 1, the entire law of sea is based on UN's commitment of under Article 1 of UN Charter 1954. A, to endeavor and maintain, endeavors to be taken by countries and global community to maintain international peace and security. Number 2, to develop friendly relationships amongst nations. Now I was telling you that, somewhere we need to draw a line, although it's a borderless. So when we draw a line, the line must be flexible and it must be open for navigation, trafficking, trade, commerce and all that, right? And even human rights as well. So flexible line must be drawn so far as in the borderless subject matter called ocean and law of sea. To develop friendly relations, as I told you, to achieve international cooperation and to be a center for harmonizing actions of states. Ecology, environment, fair and equitable, and to ensure egalitarian society, interstate disputes over sea claims. This is what the UN Charter envisage that, and this is reflected in Law of Sea Convention 1995 of UN. Quickly moving on, responsibility of state. As a state, India, for example, what is our responsibility? Our responsibility is to enforce international obligations. Article 240 of Indian Constitution empowers and authorizes central government to make laws on maritime. So central government is authorized, and at the same time it is the obligation of India to follow its commitment at international level. So Constitution of India has provided rules with respect to maritime and admiralty. So bilateral treaty arrangements India must go for, like for example with some countries, Sri Lanka also we have bilateral treaties. Bilateral treaty is international law between two countries, and multilateral agreement is a agreement law between multiple countries. Marine diplomacy, compliance with the international law, sovereignty and security, like USA. USA is very reserved about so far as their approach towards law of sea is concerned, keeping in view sovereignty and security. Article 33, I told you, amicable resolution of disputes. Quickly moving on. World legal order on admiralty. Now this is what the structure I wanted to discuss, but then I can't discuss because of paucity of time. You may go through. This is the major structure of international law on law of sea or admiralty. First document is the Magna Carta of, first document is the grand norm of the entire international law of sea, and rest of the documents are miscellaneous in nature. So I'll skip this. So this is what the UN Convention on Law of Sea, which is the exclusive document 1994, deals with. It deals with the limits, territory, because job of law is to lay down the limits and territory. Like for example, Sri Lanka and India, somewhere line is drawn, and activities are confined to India and Sri Lanka accordingly. Concept of innocent passage to ship and vessel. Here there is one major case law. Supreme Court has delivered a judgment on Ram Setu. I think that example nobody did discuss since morning. Ram Setu to be declared as national monument, a public interest litigation was filed. Supreme Court refused to declare it as a national monument. However, governmental activities and initiatives are going on to do more research, and that corridor is now open for vessels to pass. Even warships may pass through Ram Setu. That is our apprehension, because that is the national identity, and although it's not a national monument declared as such, but that is what the national identity, aspirations and a part of spirituality of majority of the people in the country. So danger is there. However, it's international law to give a route and passage to. So this is what the United Nations law is all about. Quickly moving on. Now there is one organization dedicated for this maritime, International Maritime Organization, and these are the multiple laws for each and every aspect. If you see the highlighted words, you will come to know how minutely legal rules are framed to deal, and because law should not leave any scope for any room for country or culprit to find escape route. Moving on, dispute settlement. International tribunal is there. Number one. Arbitration is there. Arbitration, you can appoint a private arbitrator to resolve your disputes, merchant disputes. And number three, national courts. Even Indian courts have been delivering judgments because a lot of claims are administrative claims are there. That's why local courts are also there. India's take on law of sea. This is what you can go through. Major Ports Authorities Act, recent law passed in 2021, which has given power to all ports authorities to fix tariffs so far as trading that takes place. Then we also have Merchant Shipping Act, wherein all merchants have to compulsorily register, all their ships are to register and all that it is there. Now Ram Setu and Dwarka also national, it's a problem of national monument, national heritage, because it's a part of ocean. So like Ram Setu also, Dwarka, the underneath temple is there. That is also part of national monument. Future course of discussion will decide this thing. All right. So consensus and challenges. Second last slide perhaps. Harmonization of laws is not there. That's a major problem. Number one. Number two, because countries are not surrendering their sovereignty for the sake of international law of sea. Number two, sovereignty as a state justification. State is always putting sovereignty as a justification for not surrendering their affairs at the helm of international law of sea. Overfishing and fishing wars are going on, and that's why militarization is happening. Climate change, environmental degradation, militarization, as I told you, as I told you just now. Seafarer-centric challenges, physical, mental health, livelihood, protection against criminalization, fair and human treatment must be mitigated. This is what the law of sea says. And maritime security as a threat of a terrorist attack, that is also a major concern. All right, so fresh water I will skip. So that's all from my side. Thank you so much. I wanted to discuss more technical rules in detail, but then due to paucity of time, it could not be possible. Once again, thanks to especially for audience, patiently listening and allowing me to speech to take 5 more minutes. Thank you so much, firstly, all of you, and also Honorable Chair for giving me this opportunity and permitting me to go ahead with the presentation. Thank you, sir, for inviting me, and thank you, Das, sir, Dr. Das, good friend of mine, for giving me this opportunity. Have a nice evening. Thank you once again.